Hello, welcome to our copyright series. I am Davis Tumwesije, your intellectual property expert. In this episode, let's talk about exceptions and limitations of copyright. So we have seen that for you to use copyrighted work, you need permission from the owner of the copyright. But of course, there are those instances under which the law grants or permits people to make use of your work without really, getting permission from the copyright holder. And this is mainly done to balance, access to information and of course the rights of the right holders. We have seen that copyright is protected for quite a long time, life of the author, plus 50 years after the death. So you can imagine there is very critical information that the public needs to know. And because of this, you cannot have that information until the person dies and then after 50 years. So that will be a little bit unfair. So there are some instances, under which copyrighted work can be utilized without really getting permission from the author. And among these, we have number one, for private use. Just imagine I'm just downloading a song to listen to as a person, okay? I'm not really interested in, gaining from it. I'm not interested in maybe selling it. I'm not interested in, commercially exploiting that work. That is highly, acceptable. Then we also have situations of administrative and, of course, court situations. A judge can, make use of, for example, a copyrighted article in his decision. Okay, this is basically for court purposes. Then, of course, in education, in research, in academia, this is very common. You are in a classroom and maybe a lecturer uses a copyrighted image, a summon, it can be speech, to drive his point home in a lecture. That person wouldn't be really infringing on copyright works. And we have also seen in academic writing, whereby you get work from different authors. But of course, the point here is to make sure that you credit these authors of that work, because this is done, of course, through referencing. This is a very common practice in academic writing. Then, of course, we have, for library, purposes and archives, there is a situation whereby you have a document that is extremely rare. It is very scarce to get. The library can make maybe a digital format of that, for preservation purposes. Then, of course, we also have for humanitarian reasons or humanitarian purposes to be able to serve, vulnerable groups of people in a given population. Take an example of, let's say, an NGO making a braille version of your work for the visually impaired, or people who are print disabled, who are unable, to read your work in the format it is. They have to somehow convert it into an accessible format, for that specific group of people. Then, of course, we also have non-voluntary licenses, or what most people call compulsory licensing. This is mainly with government. Government is free to use your work without your permission, as long as, this work is critically needed, maybe for social justice issues. Let me just give you an example. Let us assume there is a lot of genocide moving on in a country, and a certain musician has produced a song that criticizes, genocide. The government may feel it is important to have that message to the public. So without even consulting you, the government can in turn license, digital platforms, music platforms, TVs, radio stations to play your music. But of course, the government will in turn, sit it down and try to compensate you for using your work. But it has to get that work to the public in order to overcome such challenges, because the message that you have is very critical for the public. So those are some of the instances under which, your works can be utilized without really seeking permission from you. And this is widely acceptable. And these exceptions are also provided under international instruments and different countries have adopted them in their domestic laws. Thank you very much for listening. I'll see you in our next episode.